Does restricting use of an email distribution list violate free speech at ISU? That's the issue a federal judge is dealing with tonight. Good evening and thanks for watching tonight. I'm Todd Blackington. Some faculty members of Idaho State University were in federal court this afternoon as a part of a civil suit filed against the administration of ISU. This case revolves around the administration banning use of a faculty-wide email address so the Provisional Faculty Senate could distribute information. The Faculty Association filing the lawsuit claims that restriction was a violation of their First Amendment rights. About every seat was taken in the federal courthouse in Pocatello this afternoon for this hearing. There was even an ad placed in the Idaho State Journal today encouraging people to attend. In his first order of business, Judge Beelan Windmill addressed the defendant's motion to dismiss this case because the parties filing the lawsuit did not have grounds or standing to file the suit. Judge Windmill denied that motion, and the attorneys got to the meat of their arguments. Ron Coulter is the attorney for the association that's suing members of the administration. Coulter said because the administration had allowed the Provisional Faculty Senate to use a faculty-wide email distribution list, when they then banned the Senate from using the list, it was a breach of their right of free speech. Now, John Bailey is an attorney for Dr. Barbara Adamczyk and ISU President Art Bayless, and he argued that the administration has a right to restrict use of the email list because it is protecting its own right to free speech, because the administration does not want communications from the Faculty Senate to appear to have the endorsement of the administration, especially if there is another way to distribute that email. Judge Windmill asked questions to find out which previously decided cases directly applied to this lawsuit. He didn't feel he had enough information to make a decision, so the judge said he did two things today that he does not normally do. One was to ask for more briefs on his specific questions. He also allowed the attorneys more time than he usually does to make their arguments. After the hearing, I spoke with both John Bailey and Ron Coulter. Coulter said that the judge asked intelligent questions and that he believed the Faculty Association would ultimately prevail. Bailey said the hearing went as expected and the judge focused on the right points of the case.